Welcome everyone. My name is Conway Shuey and I am a board member of C2HR, and I want to thank everyone and welcome everyone for participating in today's webinar, Employment Law, Preparations and Considerations. Today is the second in the re-entry journey series of webinars that C2HR is hosting, and I encourage you to check out the upcoming topics on our website at c2hr.org. I also want to invite you to check out another feature on the C2HR website, the Knowledge Center. It's a curated collection of timely articles and resources on many topics, including a section on what else but COVID-19 that you'll likely find highly valuable in these challenging times. Before we announce today's speakers, I want to give a special shout out to the C2HR champion sponsors who made this seminar possible. Many, many thanks to the Cable Center, as well as Charter Communications. Thank you both very much. Today, I'm pleased to introduce two experts who will share their insight and experiences on this timely topic of employment law, as we all focus on not getting back to work, which is un-PC in this environment, but re-entry to the workplace. Please give a warm welcome to Barbara Hoey and Mark Conkle from Kelly Dry in Warren. Without further ado, I'll turn it over to Barbara and Mark to kick off the discussion. Stay safe and well, everyone. Thank you, Barbara and Mark.
Okay, thank you, Conway, and hello to everyone out there. Look, to launch into it, launch into reentry, it sounds like we're heading into space. At last count, we have somewhere between 42, 43 states in various stages of reopening. And this is a map of those states. You are all obviously in various stages of reopening. I'm sure you're all in different states. You have facilities in different states. You also have employees who probably range from, like many of us, working from home throughout, have not been back in their offices, to have been working throughout, to returning, to not returning. Keep in mind, none of the states that have opened or started to open meet the CDC guidance for reopening, which I believe is 14 days of steadily lowering COVID-19 numbers. There is no question that the governors of different states are taking different approaches. And I don't want to say they don't know what they're doing, but they are clearly, like everyone, launching into new territory. And it is not clear whether the phases of reopening that they're using are going to be correct or incorrect. Only time will tell. These are just some projected dates in 4 different states. What is going to happen, to be very frank with you, is it is not likely, it is 100% assured that your company at some point will be sued. The only question is, how many of those lawsuits are you going to face? And can you, recognizing you're in the HR area, can you set up a scenario where if your company is sued by an employee, to be frank, you're going to win. You're going to win, or the case is not going to go anywhere. And that's what our focus is. Mark and I know those you don't know us, or most of you don't know us, we are labor employment lawyers. We practice in the labor employment space, defending companies just like yours in charges, lawsuits, and counseling clients through this COVID-19 crisis. So what have we been seeing and what do we anticipate? This is a list. You're going to have privacy and safety complaints. You're going to have an avalanche of requests to work from home from people who have been working from home and frankly want to continue. There are a lot of companies that have been facing employee demonstrations, and the legal claims are going to range from wage and hour, I haven't been paid properly, or you're not paying me properly, leave claims, FFCRA, Family Medical Leave Act, leave accommodation claims, whistleblower claims based on safety complaints, disability discrimination, which has already been a huge challenge in the HR area, a huge challenge for us. I think you're only going to see more of that. And you're going to see other individual claims if employees are terminated, denied accommodations, or they perceive they are simply being treated worse than other employees in the same area. So what are we going to cover? We're going to cover doing and tweaking, protect your employer from these types of claims. We're going to talk about telework, which I think is going to be, it is already, and is going to become a real issue. And we've also created some real world scenarios, some hypotheticals from situations that we are already seeing happen and we can anticipate happening. Because I find that, not to get too boring, but teaching and lecturing is a lot more interesting when you apply it to the real world. So that's what we're going to do. And here we go. And I am turning it over to Mr. Conco.
Thank you, Barbara. Hi, I'm Mark Conco. And so let's get right into what are the critical components of a reopening plan. And as Barbara said a few minutes ago, we're not necessarily talking about, you know, a situation where everybody's been home and then suddenly, of course, everybody's going to come flooding back. We understand that, you know, you range across the spectrum of situations where there's some at home, some not. There are critical industries, critical positions that have been working through the whole thing. So we're talking about sort of a phased-in approach to get back to some theoretical point in the future. We don't know what that point is yet, where everybody will be back. First and foremost, you need a written plan. I'll say a bit more about this in a moment, but suffice it to say that it's great to have a plan in your head, very, very hard to implement that plan unless it's thought through, and very hard to think it through unless it's in writing. When you develop that written plan, it's important to, and you can see it on the slide, get creative, be proactive, and then ultimately to communicate the plan to the people to whom it will apply, which is everybody in your company. Now, when we say get creative, here's what we mean. You have to think almost of your physical workspace and what people are physically doing with their bodies, right? So our law firm is going through this same thing now. How do we bring people back to work? So we're envisioning, well, how many people are supposed to be in an elevator at the same time? Will there be temperature checks at the door? What about people who used to have cubicles next to one another? Are we putting up barriers, right? So it's almost like you have to track the theoretical employee through the day to think about all of those kind of touch points or flash points for exposure and how to minimize those. And to be perfectly clear, you know, we talk about liability. That's what we think about as lawyers. And in essence, we're sort of risk managers in a way. But this is not just about the money. This is about ultimately the workplace being safer. And that's a nice moral goal. But beyond that, even from an employee relations perspective, when we think a lot about that, not just the legal perspective, it's important that your employees understand, and that's the point about communicate, that your employees understand all of the steps that you've taken, the CDC guidance that you're following, the social distancing that you're going to be implementing at work, the PPE that you may be distributing. All of that is going to have people more comfortable coming back to work and ultimately to work in full, you know, productively. So I think we can go to the next one. Okay, so in this written plan that we're talking about, essentially there are 4 components. You have to implement new policies that we've never had to consider before and maybe dust off some old ones or revamp them. Any written plan is going to have to ensure safety. You have to address all the range of considerations I just mentioned. Then, this is part of the communication point, everybody has to be trained on this. Importantly, not only rank and file employees who are expected to observe, for example, social distancing or appropriate use of PPE, but what about the managers who are going to have to handle accommodation requests to continue to work from home? What is the hymnal out of which everybody is singing? That's something that has to be communicated to managers so they know how to deal with the questions and the issues that are inevitably going to bubble up from the rank and file. And then finally, and this is a closely related point, you have to anticipate, you know, you sort of, you know, hope for the best, plan for the worst, that there will be conflict. We'll address that in some of the scenarios a little bit later on. Okay, so more on why it's important to get this in writing. Thinking existing policies that you've got in place right now can address everything that you're going to be experiencing as your workforce gradually ramps up to coming back in full is a huge mistake. Why? Because all of you may have a telework policy right now. Our law firm certainly does. We never envisioned all working from home simultaneously? What about exempt or non-exempt employees, people who are entitled to overtime or not? How are you going to account for that time? What about accommodation requests, particularly in this environment? Your HR professionals, you're very familiar with, I have a medical condition, so I need some additional leave. Well, what about when the request is, hey, I have a mother who lives with me, she's immunocompromised, can I continue to work from home because I'm afraid of just even venturing out the door and getting exposed? So there's a whole series of new issues that your policies certainly were not built around. Second reason why it's important to have the plan in writing is if you don't have it in writing, if you don't have that hymnal out of which everyone is singing, what will happen, and this would happen under any HR circumstance, right? But especially now, you will have individual supervisors making ad hoc, on the spot decisions. And even if that decision is perfect in moment, and 9 times out of 10 it won't be because it's an improvisation, then it won't be the same decision that another supervisor creates the next time, right? Creates on the spot the next time. That creates differential treatment between employees, which we don't need to tell you, creates an inherent HR problem and potentially a legal problem. And the stakes are simply too high to allow that variation in your policies. So what policies are we talking about? We could talk for a long time about each one of these. This is really just to flag the issue for you. What about your work from home policies? How are you going to apply those accommodation requests in an even-handed way? What are the essential job functions in each position such that you're looking at who should come back first? Barbara is going to talk more about that. What are your screening policies? Are you doing temperature checks? Do you want to do that? Are you going to require medical testing when it's not widely available? Although that's becoming less the case, it's still not widely available. A lot of testing that is available hasn't been validated. So what's your policy? Are you going to do it or not? What is the return to work policy when somebody says, in all candor, raises their hand and said, listen, I think I was exposed to this, or God forbid, I've actually, suffered from this. Are you talking about a 14-day quarantine? Do you require testing when that employee is going to come back to work? When they do come back, are you going to provide that testing, or are you going to shift that burden onto the employee? When people are in the door, what's the social distancing rule? This is a really good example, by the way. When we say get creative and kind of get granular, what is the policy? Literally, what is the policy or the practice for, I want to hand Barbara something, a draft of something that I've been working on. Well, I can't just walk up to her anymore, right? So what's the rule there? Send it by email. If it needs to be in hard copy, do I place it someplace and say, hey, I've left it there, come pick it up? So, in a very kind of specific way, how does your social distancing policy work? What about contact tracing, right? So that's something that can happen. In other words, I get sick, Barbara's been exposed, who is she come into contact with? There are apps that actually help you do this now, but there are also employee privacy concerns. So that's something you have to think through. And then finally, and this is a huge area we'll be talking quite a bit about, including in some of these real world scenarios, what about disability accommodation requests? Where do you draw the line? Now, I think, Barbara, you'll mention later, the EEOC has actually come out with pretty specific guidance, or at least very updated guidance. Was it as of this morning, Barbara, or yesterday? On exactly the type of accommodation request you may have to consider when people need to stay home. So, and there are more than just these. Take a look at your employee handbook. Ask yourself, how would this one apply in a COVID world? And what are the new scenarios we've never had to encounter before that you see on the screen right now, for which we have to develop new policies? Okay. And I think it's over to you, Barbara.
Yeah. So I actually neglected at the very beginning to mention questions. I'm sure you're all going to have questions. We encourage the questions. Write them in. We're going to deal with them at the end for 2 reasons. Number 1, it makes the presentation go a little more smoothly. And number 2, a lot of the questions occurring to you right now, we're probably going to cover later. But we've done this before. At the very end, we're going to go through the written questions, and we will try to flag the ones that we think are going to be of the most use to the whole group. And if need be, we can stay on a few extra minutes. We're not going to, if we don't have to, cut the cord at exactly 2 o'clock. We'll try to get to as many of your questions as you'd like. So safety. The overall goal here is safety. And the first thing to consider is we're going to talk mostly about people, but obviously you've also got to talk about the property. So who's coming back? In most of our clients are doing return to work or reentry in stages or tiers, with essential people coming back first, and then people coming back in various groupings for several reasons, namely to maintain social distancing, which the CDC is recommending, and also in the state of New York, our governor is recommending. So a phased return, and at that point, you will also be forcing your managers to think about who do they really need, and are there subgroups or small groups or individual employees who can continue to work from home, even if they don't have a disability, but it's just been effective for them and they've done well working at home. You're also going to want to think about screening. We are recommending you do pre-screening before people come back to work, and then screen them when they are actually there at the door through temperature testing. You're going to think about protocols for things like elevators and meetings, maintaining that people keep that distance. That leads to hygiene rules that are going to become rules. What we all generally have always done because our moms told us to do it when we were really little kids, which is wash our hands after we use the restroom, wash our hands before we eat. They're now going to become rules that we have to employ in the workplace. I mean, the world as we knew it pre-March 12th, or whenever your COVID journey began, is not really going to return to pre-March 12th. Just like the world pre-9/11 never really went back to pre-9/11, COVID is going to change how we interact and how we behave for, I think, the foreseeable future for many of us. So who's coming back? Who are your key staff? What jobs cannot be done remotely? I think that's a forced conversation that we need to have. And notice I'm saying cannot, not can. I think the default going back was always, okay, we're all coming in. Are there a few jobs that can be done remotely? Change your thinking. Now it's, okay, let me look at this department. What jobs cannot be done remotely? The more jobs that can be done remotely, especially in these first months before there's clear testing, the safer your workplace will be, because the fewer people you have to bring back to interact with each other. So it's really a change of your mindset. Who's more at risk? People who are immunocompromised, people who are over 65, people who are residing with people who are older or immunocompromised. But you can't go about this in a discriminatory fashion. So if you're bringing people back, is it going to be based on seniority? Is it going to be based on other factors? Be objective and document. Write down why you're calling back Mark instead of Barbara. Because there are going to be people who are out there, especially if you have people on furlough, not getting paid, who want to come back because they need the money, to be frank. So if you're bringing back Mark and not Barbara, you better document why that's happening, especially if Barbara's out there on unpaid status. You're also going to think about your workplace, your space. And I know you're having a presentation next week by architects, so I don't want to spend a lot of time on this. But yeah, there's a lot of things to think about in terms of barriers, eliminating shared offices, conference rooms, lunch rooms. That's all very, very important, but not something that we are experts in, but you're going to think about that. So screening. On April 23rd, the EEOC stated that you could administer COVID-19 tests to your employees before they enter the workplace. They also say the tests have to be accurate and reliable. Do you really want to require tests? Are you a medical facility? Are you going to be COVID-19 testing and sticking swabs up people's, into their mouths or up their noses? I think, frankly, the answer is no. For most of our clients who are not medical facilities. What are the other options we're going to talk about? But you only want to require testing in very limited circumstances. What you do want to require is people prove they're healthy. Over to you, Mark.
Yeah, thanks. So sticking with that theme of testing considerations, a few things to keep in mind. Anytime that you are gathering any sort of personal or private, and certainly medical information, that's what we're talking about. All of this is medical information about your employees. I think you all instinctively know that some of those may actually be personal health information that's covered by HIPAA. A lot of it's not, frankly. So for example, the results of the temperature check would not be. But certainly from an employee relations standpoint, and then from a privacy law standpoint, you have to have a way of making sure that you maintain absolute confidentiality and that people who in the company or in your business know about it are truly on a need to know basis. Who would that be? You know, anybody whose job it is to kind of stay on top of occupational health and safety issues, human resources, right? But not generally information that you're disseminating throughout the workplace or allowing to be disseminated. And by the way, that's another policy that you should consider. In other words, what are those confidentiality obligations that your employees have? You need to remind them of those. There may be medical and regulatory requirements. I just mentioned HIPAA. There are privacy law concerns. And then, you know, this last bullet really goes to the point that Barbara just made. Ask yourself if you really need the testing at all. When you have the results, obviously you have to keep those segregated from the rest of a personnel file, maintain them in a confidential way on a need-to-know basis. But then also that's what you do with sort of the physical results or a report. But what action are you going to take on the basis of results? The only reason you're ever asking for any medical information, gathering information, whether it's a temperature check or an antibody test or an actual COVID-19, viral test, is to make decisions about what you need people to do with respect to the workplace, right? You're not a medical provider, you're not providing medical advice. And frankly, although yes, in a humanitarian sense, we worry about people, as employers and as HR professionals, well, the only reason you're gathering that information is to make decisions about the workplace. And given that, this kind of feeds into the next slide, consider what other options you have, because many of those will actually give you the information that you need to make those employment decisions. So, for example, and we've actually helped many employers develop this at this point, consider a pre-screening questionnaire. That may be just as effective as any testing. So, and by the way, in order to encourage candor, you may have to create some level of pay protection, right? So somebody feels like they're not going to be out of work, out of hours, out of income, if they're honest that, hey, you know what? I had an elevated temperature 2 days ago, woke up with a sore throat. I felt lethargic since then. So put out that questionnaire, ask people, have you had symptoms, right? Do temperature screening at the door, and make sure that it's not just that initial questionnaire, as Barbara said a few minutes ago, it's a question of checking in periodically. I may not have COVID today, but I might get exposed to it tomorrow, so it's something that you have to do on a rolling or ongoing basis. And then, Barbara, I think we're going to talk a little bit more about temperature screening going on. One quick point on that is that, again, you're only gathering information to make an employment decision right then. So if somebody's at the door, elevated temperature, are you going to proclaim to everyone standing in a line, which shouldn't be there thanks to social distancing, oh my God, Barbara has a 101 fever, go home, we're all going to die? I mean, of course not. All you're doing is saying, okay, this has tripped a wire for us to tell Barbara to go and seek a diagnosis, seek testing, let professionals do the rest of the work. Again, you're just trying to control the workspace.
So before we move on, I also want to add, we did this presentation over a 2.5-hour period over 2 different sessions. So if there are things we are leaving out a bit, you can actually log onto the Kelley Drye website and watch the longer version of these presentations. If you're also desperately bored, you can get on and watch. But seriously, some of the stuff we went into a little more detail in the 2-session version. The EEOC has made it clear, before we get off the testing, that while under the ADA you normally could not ask employees these kinds of questions, you now can. And in their more recent guidance, they have made it 100% clear that you can exclude employees from the workplace who refuse temperature testing or refuse to disclose whether they've had COVID-19 or are experiencing symptoms. You can also exclude employees who are actually showing symptoms. They show up to work coughing. It's a really new world as far as what the EEOC has done, but I caution you, look at your state and local regulations. The New York City Commission on Human Rights has come out and said they are not in favor of the EEOC's regulations. So it gets complicated depending on what city you're in. So hygiene policies, you're gonna have to mandate all that stuff that you got taught in kindergarten. Hand washing, mask, gloves, social distancing, disclosure of symptoms. What is really important is how are you going to deal with employees who violate it and make sure that you are consistent. So if you've got a senior VP who's not washing his hands or who's walking into people's offices and leaning over their computer and not showing proper social distancing, that person has to be counseled just the same as a secretary would be. You've got to be consistent. You've got to train your managers. That means distributing policies before people come back to work. You are going to want to get a signed acknowledgement on these new policies, just the way you've done, on when people enter the workforce. You are going to want to do that pre-screening health questionnaire. And I think you want to do a Zoom meeting. We're doing it. We're doing it for a lot of our clients, recording a Zoom meeting that people can watch that will explain what they will encounter on day one. So they're not walking in surprised. They're not walking in shock to see the temperature checking or all of the other stuff that's going to change. Manager training is essential. It's absolutely essential because, as most of you know, unfortunate mistakes usually happen at the manager level. And again, this has to be done remotely before they come back. Managers should not play doctor. Managers should not be guessing. Give them the list of symptoms and tell them if they see someone experiencing symptoms, this is what they're supposed to do. Explain to them how to recognize a request for an accommodation. Explain to them what information they can ask and what information they can't ask. The EEOC has made clear you can't use COVID as an excuse to start inquiring about things we couldn't inquire about before, like how's your bad back? How's that treatment for infertility going? No. It's those rules still. You can only inquire about COVID. Well, you cannot make up what an untrained manager will do. I'm sure most of you know that. And respect privacy. So that's all about training. Again, not confronting people about these situations right in front of their coworkers. And now the future of telework, the new.
Okay, so we are all in some way, shape, or form, or many of us teleworking. And we've all heard that we're, at least some quarters of society think we're opening up America again. The reality is that if we're opening up America, it's like a door with incredibly rusty, squeaky hinges, right? Just a little bit at a time. And frankly, that's the best practice and the safest practice when you're considering how to gradually ramp back up or re-enter the workspace. So Barbara mentioned it earlier. The standard has been flipped. It used to be what job, couldn't you do? Now it's what job could you do from home? And we think the safest practice and the one that's going to reduce your liability the most is to continue to encourage telework whenever that's possible. Absolutely consider a phased return. You do that by looking at, okay, here are the absolutely essential functions that we need back in a physical workplace right now. Maybe that's a first phase. Then maybe there's a second set of, I don't even think of it in terms of people for these purposes. I'd really look at sort of business functions. That's how you depersonalize it and get away from discrimination concerns. What group of people could function probably more effectively or consistently in the office? And then, what's that category of people where they really could work from home indefinitely? If you do have that category of people, while, we're out there without a vaccine, that is, I think, the safest practice. When people are back, you've got to create social distancing. And obviously, from a disability perspective and from an employee safety perspective, more importantly, you've got to take into account special accommodations for people who may be vulnerable. Those may be people who themselves are immunocompromised. It may extend, frankly, from a liability perspective or a negligence perspective, to people who live with family members who are part of vulnerable populations. There are a whole range of possibilities factually in terms of what can happen there, and those are the things you have to be prepared for. So in order to figure out who should be in the office in the first place, you want to review job functions. Can those essential functions be performed effectively at home? Are there safety concerns in those vulnerable populations, older workers, pregnant employees, people with medical conditions that make them more vulnerable? And then, are there also performance deficiencies? Now, this can get really tricky, but if somebody has been at home, able to work or should have been able to work effectively, and there are noticeable deficiencies in that work, you may want to be making employment decisions, as that person works from home over a period of time or is being brought back. In other words, one of the realities is, if Mark has been unable to work effectively from home, and that's not because Mark doesn't have the computer equipment or whatever, he's just not disciplined enough to do it. You've got to figure out, is he going to function more effectively back in the office? Is that telework situation, again, leaving aside safety just for a moment, is that a situation that we can even consider to continue based on his performance? Here's the last thing. there was an article in the New York Times 2 days ago. Now there's this whole, it's almost like a social movement where people are saying, hey, you know what? I actually just prefer, for a whole variety of reasons, to work from home. That preference doesn't drive the decision making. Working from home is a privilege, not a right. What is driving the decision making is, you've got a thumb on the side of the scale of keeping people home. But ultimately, once you decide as a business, look, we really do need this function back, make that decision, make the workplace safe, communicate that decision, and people aren't entitled to continue to work from home. But that's fairly controversial. You don't want to force people into that, but it is finally the rule.
On that point, and we've been saying this all along, the EEOC clarified in the brand new guidance that an employee who does not have a disability does not have to be accommodated with telework. So we were right. So if the person is not disabled and they just prefer to work from home, or they have some generalized anxiety about the virus, which is probably perfectly legitimate, if they're not disabled, you do not have to allow telework. It is a privilege, not a right. And the EEOC has confirmed that. It's still on you, Mr. Conkle.
Okay, so new policies and new training. And I have, there we go. So what are the new policies? This is a bit of a refresher on terms of things you've heard before. What are the, again, but we're now in the context of working from home. What are the hours of work? What are the performance standards? How does somebody know whether they're meeting expectations or not? Or how are you even measuring those expectations in the first place? Monitoring methods, right? So should you be checking when people are logging on or logging off? There could be some privacy concerns there. Generally speaking, your electronic systems are yours to monitor and police if you want. There is no, most of you will have in place an electronic systems policy that says, hey, look, these are our systems. You don't have a reasonable expectation of privacy in those systems. Now, this is a whole other area of law. You're allowed to monitor whether somebody's being productive. You can, particularly in states like California, have an invasion of privacy claim if, for example, you're monitoring something at the level of like keystrokes, or you're going into private email addresses. And once you realize that something is private in nature, you delve deeper to find out what it's about. That may well be an unlawful invasion of privacy, but generally speaking, you can monitor what's going on in your own electronic systems, which is the key way that you're going to be monitoring performance while people are working from home. And again, you make clear that if these standards aren't being met, you may not be able to continue to work from home. So last thing I'll say about this particular slide is, once you've communicated what the workplace has moved from the office to somebody's home. It's the workplace though. And so this is a dicey thing to say nowadays. A lot of people are stuck at home with kids who can't go to school. We all have been functioning, probably, if we were honest, less productively on some hours or some days than other times. So this one you have to hold a little bit loosely. But in the end, the ideal is, okay, we have to keep running the business. We're not going to do that in an office, on a set, wherever you are. We have to do it from home. That becomes the workplace. So you have to consider what are the policies that are going to regulate that workplace. Okay, and some other requirements to think about. If you're going to have somebody working from home, they need to be resourced properly to do it. Be careful. In some jurisdictions like California, if somebody, for example, gets a separate cell phone, that may be, in order to be able to work from home, that may be a reimbursable business expense. What we've been advising employers, though, is that if you're in the economic position to provide people the equipment, the tools, the resources they need to work from home, do it, right? Because in the end, that's an advantage to the company, to the employer, as much as, or even more so than, an advantage to the employee. Childcare, difficult to get in a COVID world. Where you can require it. Why? Because you're trying to free people up to work. This is one of Barbara's and my favorite subjects. Attire for Zoom or live meetings. My favorite from recent memory is in our world, there was a court conference in California. The court held it by Zoom. I'm sorry, in Florida. The court held it by Zoom. One lawyer appeared not wearing a shirt, and the other lawyer appeared from bed. Not a good idea, right? So it's okay to say, hey, we've got a professional level of attire that we expect. You've got to at least shower, comb your hair, put on clothes, right? Unfortunately, these things we would really never have to say before. And we've all seen, the guys bombing, sort of photobombing their wives during Zoom meetings, wearing nothing but boxer shorts. We get concerned actually about harassment claims in a situation like that. So make sure you're communicating entire expectations when it comes to Zoom. If you do send equipment, make sure that people are taking good care of it and are responsible for the care of that equipment, or it could cost them. And then also bear in mind, there is finally a responsibility to return to work when you tell people it's time to come back. You need to communicate that expectation and communicate that responsibility. You don't want to say to somebody on a Tuesday night, hey, need you back in the office 9 o'clock on a Wednesday morning. Why? There's no time to prepare. The person's likely going to be freaked out. So communicate well in advance. And when it comes to all of these things, we don't need to tell HR professionals, document these things. Get into writing, get employees to sign their acknowledgement of policies, not their agreement. It's not a contract, but that they're aware of what the policy is.
The point about coming in, your telework policy should say, if we ever need you to come in for a meeting in person, for a day, whatever, you, with all reasonable notice, should come in. I've had clients where employees who teleworked were asked to come in and they literally refused to show. So just put that in the policy.
Right. Okay. Important question. When somebody says, I want to continue to work from home, and we're out of the area of preference now, but somebody says, because, I've had a medical condition that makes me immunocompromised, or a doctor has told me, based on some medical condition, I really shouldn't go to work. Do you have to honor that request? This is in some ways just a modified version of a reasonable accommodation analysis that you've always done. However, the EEOC has come out with recent guidance. Telework, specifically in the context of COVID, can be a form of reasonable accommodation, right? So what does that mean? Those of you who do this kind of thing will be familiar with these concepts. So there's an individualized inquiry into whether somebody can perform the essential functions of the job, in this case, from home, by teleworking. If that person can't perform essential job functions, and you've determined, okay, we're at a stage now where that person or that function really needs to be at the physical place of work, kind of in the ordinary course, then you don't have to grant that request. But I think the EEOC, from an enforcement perspective, is really going to take a fairly broad view of what jobs can and can't be done from home. If you're working in, not applicable to this audience, a manufacturing facility, and we have those clients too, where things blow up unless somebody's operating machine, it's pretty easy to demonstrate that an essential function of the job is being physically present to run that machine. With a lot of what we do across industries, including in this one, you will be able to allow someone to continue work from home. So just be aware that telework is a form of reasonable accommodation, assuming that, or provided that, the employee in question can perform the essential functions of the job from home.
Okay. So what challenges are you going to face? And the first challenge is you're meeting Cranky Carl. Anyone out there named Carl? I fully apologize. We just looked for a name beginning with C. So let's start out with Cranky Carl has always been a pain in the butt. You know this guy, right? He's a heavy smoker. He has chronic sinus problems. He's overweight. So there's always the side like nobody really likes him. And as soon as you tell him he's supposed to report back to work, he's very susceptible for the virus. And he tells you he needs to continue working from home. He also says that his 2 children, age 15 and 17, are home from school. Schools are canceled, no one around to take care of them. We all know they don't want him around, but he is using them as another reason that he needs to work from home. So how do you handle Carl? Basically, break it down into buckets. Are these ailments disabilities that would entitle him to an accommodation? The law on obesity being a disability is all over the place depending on what state you're in, but he may be entitled to an accommodation if he has respiratory problems, COPD. Does it make him more susceptible to COVID? Does he have a doctor's note documenting this? Should his request be granted? Should he be given a trial period? I think that's a great idea for anybody asking to work from home. Denying outright, tough in this environment, especially if he comes back and gets sick. But you also have to consider how granting his request is going to affect others in his department, and whether or not you're going to get more people requesting to work from home. I don't know if any of you are subject to the FFCRA, if you're under 500 employees, but if you are, there's also the child care leave. The IRS requires, though, that a child over 14, the employee has to show a special circumstance to be entitled to that leave. You all know this already. You have to consider whether you can grant the accommodation, whether it's an undue hardship, and the FFCRA I've covered. But that's essentially cranky Carl. Moving on to the subject of lawsuits. So what about an employee suing you, which I know is all over the newspaper now, because they're exposed to COVID and feel that they got injured on the job? General refresher for the non-lawyers in the audience. In order to prove negligence, they have to prove that your conduct was the proximate cause of the injury or illness. And establishing that they contracted COVID in your workplace is going to be difficult. But if all they can show is negligence, then generally their injury will be covered by workers' compensation. You all know what that is. It covers workplace injuries. We just picked 2 states, California and New York. The employee cannot sue the company. They're limited to their workers' compensation damages. Is COVID going to be a workers' comp illness? That is yet to be litigated, but that's certainly, I'm sure for most companies, the preference. What you have to worry about, however, is what if the employee can show more than negligence? In a state like New York, for instance, if the employee can show intentional malfeasance, gross negligence, or recklessness, workers' comp will not apply and they can sue the company. And that's why we're going back to saying you've got to put out those safety measures, because if not, this is what's going to happen. 15-year employee, discount retail store, other employees coming to work with symptoms. The store allows them all to keep working. They aren't given masks or gloves. Of course, this was early in the pandemic. Unfortunately, this gentleman got sick and died. Another employee got sick and died. And where are we? It's one of the first lawsuits, Walmart. This employee is suing Walmart. His family is suing Walmart. And the complaint alleges that the store was not following CDC and OSHA guidance. So I think it stands to reason that as we are now employers all becoming more sophisticated, we have to follow that guidance, or our clients, our companies are going to be subjected to this. This is another case brought against Smithfield Foods, the supplier of bacon and pork. Again, these lawsuits are going to become more prevalent, especially as the guidance becomes more sophisticated. It's simply going to become an expectation that employers are meeting these guidelines and making their workers as safe as possible. And I want to make sure we move on to the next stage, Mr. Conkle, in cranky existence.
Yeah, so here's Carl again, and file this under the category of.
We want him to show up for work.
Yeah, exactly. So it's time for him to show up to work. He's an hourly employee working at a call center at Coronacom, the unfortunately named Coronacom, which is a phone service company. It's just reopened, and as you know, as we like to ask one another, Barbara and I, what could possibly go wrong with Carl was, we all know Carl, basically everything. The first thing that happened is that Carl has to wait in line. So you're doing what you should be doing, right? He has to wait 15 minutes to get into an elevator because of a new policy that you put into place following our advice that limits elevator use to 1 person at a time, right? Once he's in, he's got to wait another 20 minutes. Why? Because he's going to get his temperature checked. Carl is an hourly employee. He claims he's on the clock while waiting for that 35-minute period, right? And he should be paid for that time. So what do? It really depends. So this is not supposed to be a primer in wage and hour law, but Carl actually has a pretty good argument that when he's complying with your policy and he's at the physical workplace, and that actually takes some time, then that is compensable time. Now, all the regulatory authorities that look at this kind of thing will also say, look, if we're talking about a 2-minute period, a 3-minute period, in other words, minimal time, or what they call de minimis time, that probably would not be compensable. And also, I think we all know, generally speaking, time spent on a commute is not compensable time. It doesn't have to be paid. So where he was matters. How long he was waiting matters. This is a highly fact-specific inquiry. Just anticipate, though, that if you're taking your employees once they're at the physical workplace and saying, we need you to stand someplace for a while, that may be time that you actually have to pay your hourly employees for. Times only compensable for principal activities. California, to take one example, and this isn't the only jurisdiction, is going to take a broader view of what time is compensable. So the Supreme Court recently held that post-shift security checks that are performed by Apple, you may have heard about this case, really do constitute compensable time. Now, that was in a loss prevention context, not in COVID. Pennsylvania Supreme Court currently considering, you can see on the slide, a similar issue. So again, I think the takeaway from this is simply that when you have an employee who is going to be at your physical place of work, and you are having them engage in what you would normally consider preliminary activity that you wouldn't normally pay for, if it amounts to significant time at the workplace, that time may well be compensable. But in the end, you've got to analyze all the facts. You should probably err on the side of paying employees that the time is substantial. And then finally, be creative about this as well. So if one of the reasons why Carl spent 35 minutes between the elevator line and the temperature check line waiting, if you've ramped up in the appropriate way, you're probably doing staggered shifts, or a good reason to consider doing them is that you're minimizing the number of people converging at the same time. It wouldn't even have to be staggered days or staggered shifts. You could just say, I need, group A to come in at 8:30 and group B to come in at 9:30. To spread employees out and to minimize those impacts.
And cranky Carl is not done complaining. When he finally gets off the line and gets to his desk, he finds a minuscule crack in the plexiglass that divides his workstation from his neighbor's. He is very upset, and he furiously types the following email, sending it to the entire company. Yesterday, I was forced to wait in long lines at the subway at the door of my building. Today, I came in to find a large crack in the plexiglass divider at my workstation. How can CoronaCom expect us to work in such unsafe conditions? I question why we're back here so early in the first place. We know that Jane brought the virus back home, infected her mother, and then she died from it. We could be next. This is unacceptable. Of course, that immediately gets forwarded to you by the CEO, who says, do something about this. And you all know cranky Carl. So what do? There are so many issues here. What you really need to do is unpack them, okay? Are we going to discipline Carl? It depends. What happens when Jane comes forward to complain that her privacy has been violated? So what I always say to a client who calls me with something like this is, let's take a breath and let's unpack it and figure out what we're going to do. So yeah, we have whistleblower claims. The OSHA's general duty clause requires you to provide the employee with a safe workplace. You also have state whistleblower claims. That's the New York statute. We have potential retaliation claims. His complaints may or may not be protected activity, but no one can jump the gun and fire him unless we have thoroughly analyzed it. But for those of you who've looked into this, you know that there are limits on how someone can exercise a complaint. And then there's the National Labor Relations Act, which does not apply just to employees who are unionized. It can apply to your whole workforce. And he could argue that he was engaging in protected concerted activity, making a complaint on behalf of everyone, because he was complaining about why we are all here. So what do we do about Carl? I think you do safety first. You go back to him and remind him of the safety measures being taken. You assure him his plexiglass is going to be fixed. You possibly move him to a new cubicle for the day. But he needs to be reminded that he's violated Jane's privacy by revealing her situation to the entire company. And does that warrant discipline? I think it does. Does it warrant termination? I think it depends on what his prior record is. You don't want to discourage communication, but it has to be appropriate communication. And there are, unfortunately, people like Carl who will communicate their concerns inappropriately. So you keep the lines of communication open. You communicate with your employees. You document, as we said earlier, document what you've done and the measures you have taken to keep them safe and the rules that they have to follow when they come back to work. And that generally concludes the presentation. Although I am going to, we have shown you, these are links to some guidance, which you should look at. The OSHA and CDC's guidance on COVID are particularly helpful. This is also our emails and phone. If we do not get to your question today, and we do have a couple of extra minutes, so we should have time to get to some questions, we will be happy to try to answer them to the best of our feeble abilities if you send us an email. Let's see, who is our moderator and do we have any questions? I don't know.
Hi, Barbara. This is Parthavik from C2HR. One of our questions we received is, instead of updating or creating many policies, is it just as good to create one policy for COVID-19 return to work workplace policy?
Look, I think it's a great idea to create what I might call a return to work pamphlet, return to work booklet that covers a lot of these immediate issues like temperature testing, social distancing. But I also think you're going to need to look back at things like your telework policy. So I think it can be a combination of both. Before people come back, they really should be given a bullet pointed set of expectations and understandings, because it really is going to be a new world. I mean, one of the hypotheticals we left out because of time constraints was what happens when some employee like Cranky Carl comes running into Jane's office with a document, leans over her computer and wants to review it with her, and she's now freaked out because she's been exposed to the virus. He's violated hygiene policies, but he may have to be disciplined. So I think it's a great idea to create a COVID return to work handbook for the immediate. And then you've got to unfortunately go back to the regular handbook and kind of do the tough stuff and look at revising the existing policies. Would you agree with that, Mark?
Yeah, I would. And look, you know, we talked earlier in the presentation about creating a written plan sort of as an internal document, a roadmap for you yourselves to follow, and everybody's, you know, got that playbook. I think that's, you know, the process of putting that together is going to suggest to you what policies you don't have, do have. And yeah, the idea of, you know, kind of a master policy, or what Barbara was just suggesting, a good idea. Part of that may also need to be, though, that certain portions of your existing policies, so for example, disability accommodation policies, would also need to be either like suspended or modified. So in other words, if you've got, here's how we're going to handle telework requests, and that's a new policy that you're creating, or as part of this kind of compendium of COVID-19 policies you're creating, that should reference your other policies. So you're, you know, basically the people that you work with and all HR professionals understand, how is this all supposed to fit together?
All right, and then can you also, there's another question that has come up. What provisions does the CARES Act provide to an employee that may be concerned with return to work?
Well, so, you know, in terms of the CARES Act itself, you know, and the FFCRA, there are various leave provisions that largely relate to somebody having been exposed to the virus. Then there are extended leave provisions that deal specifically with being stuck at home over a longer period of time, a 10-week period, when an employee has to be at home because a child's school is closed. There are no general provisions in the CARES Act that would address, you know, what happens when an employee has kind of generalized anxieties or fears about coming back, and nothing that really addresses kind of anything else that we've talked about. In other words, we would still say, notwithstanding the recent changes to federal law, you are still outside of specific situations where somebody's been exposed to the virus, you know, is seeking a diagnosis, is stuck at home because they have to care for a child. You're still kind of analyzing a return to work, somebody's resisting returning to work against the background of, you know, what are the essential functions of the job? Does it make sense to safely bring that person back or not?
I mean, that's right, Mark. The CARES Act, just so everyone knows, reviewing this different terminology, has been so much. The CARES Act is the law that established the Paycheck Protection Program and the loan program. The FFCRA is the law that established different leaves for individuals, as Mark said, working for companies with less than 500 employees. So if you're subject to the FFCRA, It doesn't talk so much about returning to work. It does talk about what leaves they're entitled to. And it gives that individual who's under the FFCRA taking a protected leave a right to reinstatement, because the FFCRA was an amendment to FMLA. We actually did an entire webinar on the FFCRA when it first came out, and we have some guidance on our website on the FFCRA. So I would encourage whoever asked that question, if you're in that under 500 employee group, to look at that guidance specifically. But you do have to reinstate someone to their old job, just like you would if they were taking a FMLA leave, if they're taking an FFCRA leave.
All right, and I think now that you all have started, the questions are starting to come in. So could you share more about the pre-screening questionnaire?
Well, a pre-screening questionnaire is something that basically will ask 5 or 6 basic questions premised on what the EEOC has said you can ask. Do you have COVID? Have you been exposed to COVID? Are you suffering symptoms of COVID? You can also ask whether they have contact with anyone who's been exposed to COVID. And then a yes, no, and follow from that. I think if someone's been exposed or they had it, they should either be required to be tested or required to show you a negative test result. And that's essentially what your pre-screening.
Yeah, and by the way, so Barbara and I both mentioned, you know, we've worked with clients to develop these specific questionnaires. One of the things that we've combined with some of them is actually an acknowledgement. So there's a questionnaire asking all the questions Barbara just mentioned, and then I'm actually turning this way because I have the advantage of having my computer screen right here, asking an employee to acknowledge that he or she's been provided with company's policies and procedures concerning hygiene, social distancing, and all of that, that, you know, they understand they're going to comply with those policies, that, and this is kind of critical, that the employee may be exposed to risks beyond the company's reasonable control, including exposure to COVID-19. The reason why I actually think that's important, whether you do that as a separate acknowledgement or as part of the questionnaire, frankly, one of the reasons we do it as part of the questionnaire is it's just a natural way to get the acknowledgement on a piece of paper, or I guess an email sent to people, is that bear in mind that there isn't something like strict liability. You're going to do everything you possibly can to keep people socially distanced, to envision and implement a phased approach to space out people actually coming back into the workplace. But as we keep saying, once you've done all those things, COVID's out there in the world, and it's potentially going to be in your workplace at some point. And there isn't something like strict liability. In other words, if somebody gets sick at work just through, you know, routine exposure that no one could, including you, could have done anything about, it's not as if you have absolute liability for that. So one of the things that employees should understand, and there's a way, obviously, of softly delivering this message is, look, there are inherent risks out there, and you don't have to come to work. Ultimately, there may not be a job if you don't come to work, but when you do, you may be exposed to risks that are beyond the company's control, your control, really anybody's control.
You know, and on that point, I saw a booklet that one of our clients put together, which I really liked. What they said in their return to work planning is essentially they're treating their employees like adults. And people have to make individual decisions, be empowered to make individual decisions. If you do not have a disability, but for whatever reason, you do not want to commute via mass transit, or you don't physically want to leave your home, or you don't want to come to work because whatever your personal circumstance might be, we may not be required to accommodate you under the law, but that is your personal choice. And we will try to work with you, but if you can't telework and you don't choose to come in, we may have to place you on a furlough or separate with the right to rehire when things settle down and when there's a vaccine. And that is a difficult conversation, but some of my clients have had to have that conversation because we have clients who have essential employees like many of you, and they've got essential employees who've declined to come to work. And putting aside disability accommodations, if you're not coming in, we need you to come in, you're on layoff or furlough. It's your choice.
All right, we have one more question. If you've talked about video dress code, but can you also have a policy around the need to use video when you have meetings? it seems to be coming up with some of our employees that don't want to engage on video conferences due to home surroundings, etc. But it can be beneficial to see body language and make a connection.
You know what? That's a great question.
Yeah.
Are you going to answer?
No, go ahead.
He's pondering. Okay. I think that's a great question, and the answer is yes. Okay. I think when we all went out on this, in some cases with zero notice, we've given everybody a lot of slack because they're working from home and they weren't prepared to work from home. They didn't have the equipment, they didn't have the office, whatever. Okay. If you're now choosing to work from home, it is a privilege, not a right. And yes, you can require them to participate via video, which means going back to what Mark talked about, they have to have an office environment. They have to have a professional backdrop. I don't know how to do it, but Zoom can give you a backdrop, a false backdrop. Mark, can you do that?
Yes, I'm doing it as we speak.
Okay. But seriously, I think the answer is yes. And that's going to be a nudge to look, if you're not going to do this, if you're not going to sign on to the conference call, and there he is, looking as handsome as ever, but with his backdrop. Yes, you can require them to participate by video. And yes, it's about participating. We had a question on the last one. What about someone showing up for a call or a meeting a little bit drunk or seeming a little bit under the weather, let's just say at 4:30 in the afternoon? You're at work. If that person shows up for a video meeting seeming inebriated or under the influence of something, you're going to treat them, and you should treat them the same way as if they showed up from a lunch meeting or showed up to work inebriated. They've lost that privilege, and they are going to either be coming back in or terminated. It really is, it's different, but it's not different in that regard. Would you agree with that, Mark?
No, yeah, I certainly would. And, you know, I think from an HR perspective, it's always important to have individual circumstances in mind. I can imagine some situations in which an employee has, you know, things going on at home, or they live in a particular place where they may be embarrassed. So, you know, not from a legal perspective, but from an employee relations perspective, you may have to have some conversations, and certainly a lot of sensitivity around that. But if the preference, as Barbara said, is just that they kind of don't want to be on Zoom, it's hard to look at yours. I actually hate myself on Zoom, you know, and don't like how I look. If that's kind of the reason why, you know, ultimately, as we've been saying, you create a workspace that is actually, you know, now at home, you create the rules for that workspace just like anywhere else. And I think, did you say that was the last question?
We got one more, and I think, and then we'll, just one more, and I think this will be the last one. What about employees' non-ergonomic workplaces at home and employer liability? Is there any?
No, not necessarily. So if somebody requires some special equipment, including ergonomic, say office furniture because of a disability, you would handle that request like any other accommodation request. You know, do you have liability because somebody's sitting on a dining room chair and the level's too low and they develop carpal tunnel syndrome? I mean, look, this is an open question. I haven't seen that lawsuit yet. I think the answer, though, is no, because you're not necessarily requiring that somebody sit in a particular posture or whatever. Now, as we said before, to the extent you can keep employees resourced to work effectively from home, and it really is slowing somebody down, we're not suggesting you should never consider that. But if the question is, are you legally required to provide ergonomic office furniture? I think the answer is no. Barbara, what do you think?
No, I agree with that. I mean, I think Mark knows I'm sitting on my dining room chair right now. But you are required to provide them with the equipment they need to dial in to the office. So you may be required to provide a laptop. It depends on company policy. It depends on the state you're in. And I think for your own security, and there's been a lot of talk about technological hygiene and making sure that people are not hacking into your data. A lot of companies supply laptops simply because they don't want people on their personal laptop accessing company or customer information. I know a lot of you deal with customer information, billing information. There are a lot of reasons why you want to keep that data off someone's personal system. You don't want it on Gmail. But putting that to the side, once you've supplied them with the technology or made sure they have the technology, I don't think the law does not, except in California, where there are some different requirements. The law doesn't require you to buy them office furniture. And I don't know that you could be liable for a workers' comp injury if the person is injured in their home. It's not your workplace. You don't control that workplace.
To follow up on that question, someone asked, are the companies responsible for paying for their employees' internet services since they're working from home?
Again, in most jurisdictions, no. In some jurisdictions, if somebody got internet service or had to say upgrade internet service specifically because an employer is requiring or requesting that the employee work from home, that could be a reimbursable business expense. For example, I wonder whether in California that would be reimbursable. It's a state-by-state answer to the question. So I don't know, consult with some good employment attorneys if you're concerned about a particular place.
All right, well, wonderful. First of all, I want to thank you, Barbara and Mark, so much for your time today, for presenting this webinar to our C2HR community. As you can see from the questions, everyone found it highly valuable. To the people on the call today, thank you so much to our members for tuning in. And next week, we have 2 more webinars for the re-entry journey for all of us on May 12th and May 14th. And finally, I would like to thank our C2R champions, the Cable Center, and Charter Communications. Thank you all, and everyone stay safe and well. Thank you.
Thank you.